members. I'm Lin McCraw, and Vice President of Texas Comptrollers Association for Legislative Affairs, and we're testifying against the bill. There are several reasons, but to get to the reasons, you got to really fundamentally understand the difference between traditional insurance and workers' compensation insurance. Workers' compensation insurance is a no-fault insurance. The insurance company is the client of the lawyer, not the insured in this particular case. That's the way it's designed. It's designed that way to protect the employer-employee relationship. As a result of that, the workers' compensation statute provides administrative violations if a carrier instructs an employer not to file documents, encourages an employer to violate the claimant's rights, allows an employer to dictate the methods by which the terms of the claim is settled, if they fail to initiate or reinstate a benefit when due, if they controvert a claim, if evidence clearly indicates liability. Okay? Those are all administrative violations. There's also administrative violations if you fraudulently deny a benefit for misrepresenting or concealing material fact, fabricating or altering, or concealing fact, or conspiring to commit those actions. The concern is that we have seen in what used to be bad faith litigation happening all the time, employers and the insurance companies conspiring to harm employees. And currently the Supreme Court ended up not allowing those bad faith actions to go forward because we have these administrative violations and because TDI can enforce these administrative violations. In addition, the employee still has a cause of action for discrimination in the event something wrong. In the event we do have this kind of collusion that we're concerned about. Right now, there's nothing that prevents the company and the insurance company from talking. There's nothing that prevents them from telling them the true facts. The company just cannot control or attempt to control the resolution of the claim, and they are responsible for their communications to make sure they're truthful and honest. The concern here is this proposed change encourages the concealment of fraud against the employee. That's the concern. If there's very limited or no discovery of that, no light comes to it, it's green light for wrongdoers not to be held accountable. It would prevent TDI from doing its job. If this information is confidential, TDI never learns about it. They never know about it. They're not involved in that court case if it ends up going to court. So they cannot then discover these administrative violations that we used to see in the bad faith context back when those causes of action were allowed. This is one of the only avenues left for the employee to make sure that his claim is disposed of appropriately. In addition, this would pit employers against employees. This is supposed to be no-fault insurance. The employer is not supposed to be a party to this. We do not want to encourage employers to be adverse to employees when an injury claim is made. I know that some people think, well, in practical reality it happens all the time. Yes, it does, but it shouldn't be happening. It's not supposed to be happening. The design of the law was not for it to be happening. In addition, it allows decisions based on secret evidence. If we have these confidential communications, the employee could never know, even if a judge reviews it, the employee could never know what secret evidence was used to dispose of his or her claim. As a result, the employee's other avenue would be filing these 451-001 discrimination cases. This could actually lead to increased litigation against the employer directly by the employee. The bill has many problems because of that. This bill really confuses a simple and important legal concept of what should be attorney-client privilege information, and it will harm the integrity of the judicial system if you do it. We're going to end up it's going to end up creating a lot more problems than it is supposed to solve. And with that, I ask if anybody has any questions.
Thank you, Mr. Chairman. Lynn, I think that earlier I heard you say something about fraud, communications of fraud within the employer and the workers' comp carrier. If an employer takes a conflicting position than that of the carrier, will that prevent the disclosure of that information under the confidential communications
Well, understand that the confidential communications are between those two individuals. The one draft that I saw, and I'm not sure if it's in this draft or not, one draft would allow one to impose the duty of confidential against the other. I'm not sure if this draft does that or not.
Okay.
But in any event, the draft that I was thinking about, if there was an action against the insurance company by the employer or by the employer against the insurance company, either way,
yes,
then that information could be used. But the draft that I saw, any person could have used it. Either one of the two parties could have used it against the employee.
Against the employee.
And that may be an old draft because I've looked at another draft since then.
Well, in the draft that you've reviewed, how far down does the confidential communications go? Is it only for like the president of the corporation or the employer, or does it go down to like low
it doesn't
coworkers?
Say. It doesn't say, but it would be my consistent with law that we have now that it would go down to an employee who has an ability to bind the employer with, so it would be an officer or somebody that was specifically appointed to do that on behalf of the company.
Okay.
That's the current law.
But this bill would be overreaching in terms of allowing the confidential communications to go.
Well, there's no need for the confidential communication to exist at all. The only way that we're going to see this ever actually occurring on any individual's case is if they're attempting to conceal fraud. And there's nothing right now that prevents a judge from saying if a claimant says, I want to know about any communications insurance company and my employer had about rates or about other cases or anything like that. There's nothing that prevents a judge right now from issuing a protective order. And if the judge won't do that, there's mandamus procedures. All of that's available to prevent any type of truly confidential communications that are global in nature. But since the employer is not supposed to be dictating or working on the claim with the workers' comp carrier, I mean, all they're supposed to be doing is giving facts. Since all they're supposed to be doing is giving facts, there's no need for this confidential communication unless people. Well, let's put it this way. It opens the door for people that would commit fraud to commit fraud and get away with it. And that's what we're concerned about. It's not saying that they all do it. It's saying that this opens the door for that fraud, and it's our position that for that reason, and it's unnecessary that we don't need this, and it should be opposed.
All right, thank you.
Any other questions, members? Thank you, sir.
All right, thank you.